Hello everyone. In this video, we will talk about the 42nd Constitutional Amendment. I have already mentioned this topic and expressed this topic in a board in Hindi language yesterday, and today I'm going to discuss this in English language. And let's talk about that. And at first, welcome on this channel. Mm, so, 42nd Constitutional Amendment. Uh, in the history of the Indian Constitution, before 42nd Constitutional Amendment, we already have seen 41 Constitutional Amendment, and among them, the most important constitutional amendment was Keshavanand Bharati versus State of Kerala case. So basically, it was the case of Land Reform Act by the State of Kerala. But the most important part was that it gave us the theory of basic structure of the constitution, the doctrine of the basic structure. So, what was this theory, the doctrine of the basic structure? So, in the constitution, we have a certain kind of facts or the elements or the values which can never be changed and which can never be removed from the constitution. So this is the basic value and basic structure of the constitution. For example, we can take the equality is the uh, part of basic structure, equality and freedom and separation of power and freedom of judiciary and dignity of life. And most important is judicial review. So these are the some values and some elements which can never be removed from the constitution. When the government is in majority and even by the two-third majority, then also this is not possible to remove these values from the constitution. This is the part of the basic structure. So the most important, the most controversial was judicial review in this basic structure theory. So basically, this judicial review is a dynamic of phenomena. It means that the judiciary always uh, explain the uh, by this about to the constitution. Judiciary always expresses the thought and clarify the meaning of the constitution as per the time. So right now, before Samir, they told us about the right of life with dignity, and in Article 21 they have expanded this. So these are very dynamic phenomena, and the problem was that the government of that time was feeling that judicial review is somewhere decreasing the value of the parliament. It means that by this case, the supremacy of parliament was decreasing, and it was establishing the supremacy of the judiciary. So government of that time wanted to that all power which can amend on the constitution. So government wanted that time that the supremacy of the parliament and its all power should be always there, and nothing can reduce them. So now the story begins from here. Now we see that what another point was there. So basically, it was the time of 1976, and the time was emergency in 1975. The country was under the emergency. So all the leaders was imprisoned that time. So there was no any opposition when this Amendment Act came, and there was no any person to question that there was a democracy, because the government was elected democratically and by the two-third majority. So uh, it had the whole right to amend the constitution, because Keshwanand Bharati, in the case of Keshwanand Bharati versus State of Kerala, the decision was by the ratio of a 7 ratio 6. It means just by the one judgment, the one judgment, the decision came, and Chief Justice of India was there in the majority. And in from another side, they wanted that the voice of the nation by the parliament should be remained always. So they wanted that this kind of the power should not be given to the judiciary, which reduces the power of parliament. So it was a conflict between the judiciary and executive. So basically, that time the country was in the emergency. So we are talking about the background of this 42nd constitutional amendment. It is also called the mini constitution because it touched the various aspect of the constitution. We will see further. So it is also called the mini constitution. Some of remained as it was, and some was changed by the government of Janata Dal, and then by the judiciary, by the Supreme Court. So, at the first point was the background. In the background was the emergency, and why the emergency was imposed. The reason behind this 42nd constitutional amendment we are talking about. So, in emergency, in the case that was the case Indira Gandhi versus Raj Narayan. So Allahabad High Court has gave their decision and cancelled the 39 constitutional amendment. So what was there, that the president and the vice president, prime minister and the Lok Sabha speaker, so the election of this person can not be questioned, and cannot be judicial review can be done of the election of this person. So court found this unconstitutional and cancelled this 39 constitutional amendment. So what happened with this particular case, the election of the prime minister of that time, Indira Gandhi, was cancelled, and this was also became the biggest reason as the background of this 42nd constitutional amendment. And so there was we talked about the time period was the emergency. Second one is the basic structure doctrine, which was given in that case, Keshwanand Bharati versus State of Kerala, and the third one was the cancellation of the 39 constitutional amendment. Now, the center theme of this 42nd constitutional amendment was the ideology of socialism. The government wanted that time the socialism for the nation. The socialist ideology was in the center of that time in the government's mind. So everyone, especially the developing country in all over the world very curious about this phenomena, the socialism, and everyone was very curious to talk about this socialism and to be called their nation socialist nation. What and even to reduce the value of capitalism, it was also there in that time, the nation uh, which were ruling in that time in our world. So the government wanted the idea of socialism that time, so very central theme was this constitutional amendment was socialism. Now we see that what this ideology socialism acting in this amendment act. So there was a minister Swarna Singh in the cabinet, and they told to the prime minister that if if she wanted socialism in the country, so it should be there in the constitution, because as this particular word there was no any mention of the socialist word in the constitution. So the committee recommended to add this word socialism there. So in the preamble, the socialism included, and and with this socialism, the security already comes with it, because if the secularism will not be there, so socialism cannot exist. So that is why it's already came along with the socialism. And then the integrity, because this all element can be exist only when the reason, when the nation will be integrated. So socialism and secularism and integrity, these three words were included that time by this constitutional amendment in the constitution by the recommendation of the Sardar Swarna Singh committee. And the question also was asked by this committee that uh, this democratic structure, democratic election process can be changed by the Adhyakshi Sasan, by the head of the state government. Can we change this? So the committee recommended that there is no any need or the necessity of doing that. There's no any sense. Now we come to the part 3 of the constitution, which is the fundamental right. Now see that what the changes this 42nd constitutional amendment did to the fundamental rights. So there was a right of wealth in part 3 in the fundamental right. Now this was the conflict against the socialism, because this was the characteristics of capitalism, to right have of wealth. So what the government did, the government decreases the value of right of wealth, and for decreasing the value of this, what they are doing, they have declared that every DPSP, directive principle state policy, will be primary from the article number 14, 19 and 31. Later in the case of Minerva Mills, it was reversed, and the decision came that not the all DPSP but 39B and C will be primary from article 14, 19 and 31 of fundamental rights. And now we see in DPSP what has changed. So in DPSP there were there were of free legal assistance by the article number of 43A. This was change done in DPSP. And another thing was the participation of workers in management. This was also done in DPSP by this act, this 42nd Constitutional Amendment Act, because the form the feature of this the this 39A and 43A. This was in the nature as socialist features. So government included in DPSP this socialist features element, the provision in the DPSP. Now, another thing was the environmental protection were also added in our DPSP by this constitutional amendment, 42nd Constitutional Amendment. And now we see to decrease the supremacy of judiciary and to establish the supremacy of parliament, what the government did. So we had the 368 article number 368, the amendment, constitutional amendment provision were mentioned there. So in subclause 4 and 5, what the government said that time that parliament has a right to change everything in the constitution, and this can never be questioned in any court. This was two provision there in 368 4 and 5. So it was for the establishment of the supremacy of parliament and to decrease the power of the judiciary. What they did that in the case of Indira Gandhi versus Raj Narayan, the Allahabad High Court has cancelled the election of Prime Minister. So what the provision did by this act that the Supreme Court only will listen the parliamentary activities or the changes or the laws, and High Court will listen the state legislative activities or acts, and High Court cannot listen the parliamentary affairs. This was the biggest change because in our country the judiciary works in parallel way. So this was the biggest change to reduce the power of judiciary, and also the provision of 6 year of the government was by this 42nd Constitutional Amendment, as we now see that 5 year of the tenure of the government is a 5 year, and then we again enter to the election after every 5 year. So it was increased, enhanced by 6 year. Later it was cancelled by the court and by Janata Dal Sarkar. One more important feature was the fundamental duty, which was added in 51 Article 51A in the Constitution. This was the duty for the citizen of the country, for the people of the country. So it was not happily accepted that time because the citizen were asking to the government that they himself have failed by their duties and they are teaching us the duty. So it was not easily accepted. that time. um, for the reducing the power of the president, what it did, so the there were three in parliament system: Lok Sabha, the lower house; the Rajya Sabha, which is the upper house; and the president. So the executive and the legislature whole the power was under the government, because when the government is in the majority, so um, nothing can beat them. But the main important feature was the power of the president. When some of the power which was given to the president, if president uses that, the powers by their conscience. So if the president uses such powers, so something uh, something can be possible to um, for removing the government from their place. So what this act did, and what that type of government change in the constitution, that the president will shall act by the assistant and recommendation of the cabinet always. This was the change in 74A in the constitution. And also the tribunal came, which are still in existence and working powerfully, and even the number of the adhikar and the tribunals are getting increased day by day. We have the uh, environmental adhikaran, the tribunals. We have mentioned the article number A and article number B. So we have this provision also by this act. So some of the features was removed by the court, and the court found this unconstitutional, and by the Janata Dal Sarkar. So the right of wealth, which was in the fundamental right, so it was shifted to the general law in 300A by the Janata Dal government. And the all powers which was reducing the provision which was reducing the power of the court, the SC can listen only the parliamentary affairs, and the High Court can listen only the state legislature affairs. This was removed by the judiciary. And the 6 year tenure was removed again. The 5 year the government tenure will be, it was provisioned again. And tribunals are still there. The cabinet power under 74A it is still there, and fundamental rights are there. And article number 368 4 5 subclause was removed. There is nothing like that parliament can change the every whatever they want in the constitution, and can never be questioned in any court. That was removed. And what another thing is that 39 constitutional amendment was already removed from, and uh, and everything was this. All DPSP will be primary. Then article number of 1490 and 19 and 31, so it was also removed, that not every DPSP but 39B and C will be primary. Then article number 14, 19 and 31. So this was the explanation of 42nd constitutional amendment. And so how it balanced after the decision came, the separation of power, and how the federalism of the nation can be safe. It shows that it establishes the later decision came. It establishes the supremacy of the constitution. Neither a parliament nor a judiciary, but the constitution only is supreme. So we will be here with another topic. So thank you so much, and thank you so much. Bye bye.